Good evening to all of you. My name is Professor Raj Kumar. I'm the founding Vice Chancellor of OP Jindal Global University and Dean of Jindal Global Law School. It is indeed my proud privilege to welcome all of you to this virtual release of the book, The Law of Emergency Powers, Comparative Common Law Perspectives, authored by Dr. Abhishek Singhvi and Professor Kagesh Gautam, and published by Springer. Namaste to all of you who have logged in from different parts of the world to share this important occasion, and thank you for being with us today. Today is a very special occasion as we release this book. I also want to extend a warm welcome to our very distinguished individuals who are present here, who have taken time from their precious schedule to be part of this occasion. Our humble gratitude to Hon'ble Justice N.V. Ramana, Judge of the Supreme Court of India, who is here today to commemorate this moment by releasing the book shortly. I would also like to extend a warm welcome to the great visionaries and leaders in the world of law who have taken the time out to be here on this important occasion. Honorable Dr. Justice D.Y. Chandrachud, Judge, Supreme Court of India, who will be with us shortly. Honorable Mr. Justice Suryakant, Judge, Supreme Court of India, and Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India. Thank you very much for being here, and I welcome your esteemed presence. My special thanks to Ms. Nupur Singh, editor of Springer Nature, for also being with us. A very warm welcome to all of you, and once again, thank you for being here. We are live on Facebook and YouTube, and I look forward to the participation of the audience in this program. 2020 has been a life-altering experience. From the get-go, it has been a year of unprecedented situations and emergencies of significant magnitude never witnessed before. Therefore, in a time like this, the book, The Law of Emergency Powers, Comparative Common Law Perspectives, is going to be the type of intellectual guidance the world around us would like to have. Allow me to share with you a little more about it. This book presents a comprehensive legal and constitutional study of emergency powers from a comparative common law perspective. It is one of very few comparative studies on 3 jurisdictions, and arguably the first one to explore in detail various emergency powers, statutory and common law, constitutional and statutory law, martial law and military acting in aid of civil authority, wartime and peacetime invocations, and several related and vital themes such as the judicial review of emergency powers. The 3 jurisdictions compared here are the pure implied common law model employed by the United Kingdom, implied constitutional model employed by the United States, and the explicit constitutional model employed by India. The book's content has important implications as these 3 jurisdictions collectively cover the largest population within the common law world and also provide maximum representative diversity by providing a detailed examination of the law and practice of emergency powers. The book shares a wealth of valuable insights. Beautifully summarized by Professor Seetal Kalantri, a professor of law and faculty director of the Cornell India Law Center at Cornell Law School in the US, and I quote, she said, "In the Law of Emergency Powers, Dr. Abhishek Singhvi and Professor Kagesh Gautam provide a timely and rigorous comparative analysis of emergency law in India, the United States, and the United Kingdom. In response to COVID-19, governments around the world have used their powers to declare emergency and abrogate civil rights and civil liberties and human rights. This book engages with important questions that will be asked for many decades after the pandemic ends. When is it appropriate for governments to utilize their emergency powers? How can we determine if the government has overstepped its powers? And who determines when the extraordinary circumstances have changed? Anyone who cares about these questions should read this book," unquote. As we continue to live this pandemic era, demands for justice have only escalated. The judicial systems worldwide have the responsibility to address these demands and play an instrumental role in bringing back the equilibrium to the world around us. Therefore, I can safely say that this book will have tremendous impact on the way we are able to evolve from the current crisis. Professor Philip Allott, Professor Emeritus of International Public Law at the University of Cambridge, UK, Fellow of the British Academy, couldn't have said it better when he said about this book, and I quote, "This book could not be needed more or more urgently than it is at the present time," unquote. Thank you indeed, Dr. Singhvi and Professor Kagesh Gautam, for such a timely intervention that this book will bring to the world of law and justice. Therefore, without much ado, allow me to invite Dr. Abhishek Manu Singhvi, who has put in years of his wisdom and experience into the book, which I am confident will make a powerful impact by the mere virtue of his invaluable knowledge being present in this book. Dr. Singhvi is an eminent jurist, senior third-term parliamentarian, visible media personality, well-known columnist, author, thinker, and commentator. At the age of 34, he was the youngest designated senior advocate of the Supreme Court of India, and at 37, he was also the youngest additional Solicitor General of India. He's also been a former elected vice president of the Supreme Court Bar Association and a former chairman of the Parliamentary Committee of Law, one of the senior most national spokespersons of the Congress Party, and former chairman of AICC Law and Human Rights Department. His lineage in law goes back to his early academic years. After obtaining his BA Economics degree from St. Stephen's College, Dr. Singhvi went on to complete his master's and PhD at the Trinity College, University of Cambridge. He has lectured to student and faculty groups and general audiences at Stanford, Harvard, Yale, Boston, MIT, and many other institutions. He was also a visiting Trumbull lecturer at Yale University in 2011, and I would like to proudly say that he is currently an honorary adjunct professor at Jindal Global Law School, OP Jindal Global University. Thank you, Dr. Singhvi, for gracing us with your esteemed presence today and sharing this very important landmark release of the book with us, which will be an instrument of global change. Dr. Singhvi, over to you.
Honorable Justice Ramana, Honorable Justice Chandrachud, shortly about to join us, Honorable Justice Kaul, Honorable Justice Suryakant, Vice Chancellor Raj Kumar, Kagesh Gautam, Professor Kagesh Gautam, Nupur Singh, and all my friends in the legal profession and elsewhere, now or later watching this program. Thank you, Raj, for a very generous introduction. Let me start by expressing a personal debt of gratitude to the chief guest, Justice Ramana, and to the three honorable learned Supreme Court judges who have made time for this book release. I fully subscribe to the view that the more these judges are left alone after 5 days of overwhelming harassment every week, the better it is for everyone. After all, even on weekends, howsoever precious they are spent, as far as they are concerned, with SLPs, with other professional judicial commitments, and family, sadly in that order. Additionally, Justice Chandrachud is about to join us, is doing so despite some indisposition. My special thanks to Vice Chancellor Raj Kumar, whom I always think of as a very, very special bundle of dynamism and energy. And indeed, he is the moving spirit, both behind this publication and this release function. My prolegomenon, which is a fancy thesaurus word we picked out for the word preface, says most of it. It talks of the personal, it talks of the academic, and it talks of the emotional. It has indeed been a very special travel down memory lane, since it rewinds over 35 years to the early 80s, when I conceived, labored, and delivered a bonny baby, comprising a 2 lakh word PhD thesis in 1985 at Trinity College, Cambridge, England. Therefore, its publication as a book is for me no less joyous than the birth of a new child. Some of the amusing and memorable flag posts on that long journey include the startling result that after I had spent some 6 months at 82 or so, meandering through a humongous forest of materials on the heavily trodden path of due process, something at that time which fascinated me, the word due process, I ended up doing a PhD on its obverse and opposite, namely suspension of due process, which is another name for emergency powers. It is, interestingly, and I was surprised myself, a matter of some satisfaction that 30 years after its writing, this book remains the first and only comprehensive constitutional study of emergency powers in a comparative common law perspective. I don't say it as a boast, but I say it with some surprise and with pride, that in a comparative common law perspective, there has been no constitutional study of this subject. It is also the first one dealing in such detail with varied forms of emergency powers. As Raj has just said, constitutional, statutory, common law, including martial law, the distinctions between martial law and military acting in aid of civil authority, wartime, peacetime, invocations, and an important sub-theme of judicial review of emergency powers. Rightly or wrongly, it is also the most heavily footnoted academic writing on the subject globally, with the highest granularity of detail, and thereby, learned judges, hangs a tale. Though Cambridge had already given me a special extension of the word limit for the PhD from the normal Cambridge limit of 80,000 words to an enhanced limit of 1 lakh words, in the view of jurisprudence from 4 jurisdictions, I put out a second volume for my PhD examiners, which comprise an additional 1 lakh words only of footnotes. That is a way of circumventing the word limit and maintaining the research which I had done. Much of that you will find in this book, although this is a little abbreviated version, and I can tell you that one part of that original thesis we have kept out altogether, which is the 4th jurisdiction, the international law jurisdiction, where you have a wealth of similar material from the European Commission, American Commission, etc., which will hopefully be subject to the publisher's pleasure, a sequel in a separate volume after some time. There are many laments one can make about the state of legal education in India, and I have had occasion to air them recently in a valedictory address at Jindal University. But in the context of this book release, I think it would not be inappropriate to underline the glaring absence of genuine legal research in large parts of India. There are, of course, islands of exception, but I say large parts of India. Part of this is because of the many factories of legal education we produce with hardly any quality control. The negative impact of stratification of law colleges must be urgently addressed. Central universities set up by Parliament operate their law faculty as the law school, while state universities act mostly as affiliating universities, which are affiliating colleges set up by private trusts and societies. The major problem facing Indian legal education today, and in particular, good, solid, original legal research, is this affiliated law college system. There is an institutionalized mediocrity and dilution of academic standards in a large number, I will not say all, of such affiliated institutions. Many do not have adequate and qualified faculty or law library or e-resources, and they omit even regular classes and examinations. Mushrooming of law colleges contribute to the dilution of standards in both legal education and in the legal profession. For example, the 3 state government universities of Western UP, to give just 3 out of many examples, at Meerut, Agra, and Kanpur, have 107, 40, and 67 law colleges affiliated to them respectively in just these 3 cities. These 214 law colleges in all offer 20,000 plus seats in the LLB degree program alone. They also grant PhDs, which in many cases, I'm sorry to say, would not fit that appellation at all. Madras High Court, of all courts, has in fact said in 2017 that 85% of law colleges must be closed to maintain the sanctity of the legal profession. Of course, that may be an exaggeration. But on the contrary, we have over 1,500 law colleges in 2019, compared to less than 800 in 2000. So we have added 600 new law colleges in 9 years alone, in the last 9 years, prior to 2019. One of the major reforms needed is to close down at least X number of mediocre, dubious, and substandard law colleges who may not have the foggiest idea of legal research and indeed make it into purely a profit-generating business endeavor. As I end, I must say that my debts are recounted in greater detail in the book. To Professor Sir William Wade, who was much more than my supervisor, he was a friend, a philosopher, and a guide, especially during the lonely furrow of mine as a PhD researcher, made more insecure by being told by many that I was a fool not to start law practice early. To Mr. Trivedi and Mr. Majmudar of the then most reputed publishers Tripathi and Company, who used to visit me regularly on a monthly basis in Delhi to implore me to either allow them to convert this massive thesis to a publishable book or to do it myself. And I would regularly allow the perfect to become the enemy of the good amidst the vortex of an increasing law practice. To the librarians of the Squire Law Library at Cambridge, the Institute of Advanced Legal Studies in London, and the Indian Law Institute in Delhi, who extended themselves beyond the call of duty to help me in my research. But the first one in particular, the Squire Law Library in Cambridge, requires a special mention because they gave me a special key as a special exception. It's a very large, old, 200-year-old colonnaded building to enter the building 24/7. And I spent many nights with only Dutch courage in this colonnaded building amidst the possible company of ghosts to finish this PhD in record time. And of course, to Vice Chancellor Raj Kumar for finding Professor Kagesh Gautam, just the right person for the right job at the right time. Kagesh has the academic's curiosity for ideas, backed by the discipline for relentless research, and we updated this book in the last 1 year quite easily. Some acknowledgements, of course, are foundational, more personal in nature and even existential. To my late father, Dr. L.M. Singhvi, for being an ideal to inspire and to follow. To my mother, strangely, for being the only person to suggest that I forego some years of law practice to finish the research. To my wife, who toiled ceaselessly in those days, uncomplainingly, she was different then, on a newly invented IBM transportable computer. It was invented just when my PhD became ready for typing. And it was called transportable because it weighed 20 kilograms, 3 feet by 2 feet. Sacrificing the many hours and days that were justly hers as a 3-year-old bride. I am, of course, deeply obliged to the publishers, a most reputed international brand in the realm of law publishing, for prompt and efficient midwifery for redelivery of my baby as a book in this new avatar, and especially to the representative, Ms. Nupur Singh, who's here with us. My very deep gratitude to the learned judges, once again, to each one of you for your gracious presence. Thank you.
Thank you very much, Dr. Singhvi, for this fascinating address, a deeply inspiring set of reflections in your journey itself. There's so much to learn from you and indeed the journey of your life, and this book is truly going to make a tremendous impact. This thought, in fact, is beautifully resonated in the words of Honorable Justice R.M. Lodha, former Chief Justice of India, who, reflecting on the book, said, and I quote, "The edifice of this book, The Law of Emergency Powers, rests on the work prepared as a PhD thesis by Dr. Singhvi few decades back." He also said that, and I quote, "The most interesting aspect of this book is that a comparative study of emergency powers has been carried out of 3 democracies, one of which has no written constitution, United Kingdom. The other mentions emergency powers in part 18 of the world's longest constitution, India. The discussion on the topics such as can martial law be proclaimed under Article 34 and president's rule as sui generis emergency power is thought-provoking. Everyone serious about the emergency provisions prevalent in India and the US, the 2 biggest democracies in the world, and UK, needs to read this book," unquote. On that note, I would like to invite Honorable Mr. Justice Suryakant, Judge, Supreme Court of India, to honor us with a special address. He's one of the luminary leaders in the world of law and has made significant impact as a judge of the Supreme Court of India. He is a judge of the Supreme Court of India and the former Chief Justice of the Himachal Pradesh High Court. He was appointed as the youngest Advocate General of Haryana in the year 2000 and was later designated as Senior Advocate by the High Court itself. He held the office of Advocate General till his elevation as an Honorable Judge of the Punjab and Haryana High Court. In 2019, the Collegium elevated him to the Supreme Court of India. With those words, let me have the honor and pleasure of inviting Honorable Mr. Justice Suryakant to deliver his address.
Thank you, Professor Raj Kumar. Honorable Mr. Justice N.V. Ramana, Chief Guest of today's event. Honorable Mr. Justice Chandrachud, who will very soon join us. Honorable Mr. Justice Sanjay Kishan Kaul, Dr. Abhishek Singhvi, Professor C. Raj Kumar, Professor Kagesh Gautam, Ms. Nupur Singh, esteemed members of the bar, representatives of the publisher, and my dear friends. It is my pleasure to be virtually present among all of you for the launch of a book which marks the culmination of the doctoral efforts of India's leading senior advocate, Dr. Abhishek Manu Singhvi, and its contemporary adaptation by an upcoming jurist, Professor Kagesh Gautam. Supplementing what Professor Raj Kumar has already stated about the book, I wish to add that with the aid of a cross jurisdictional and interdisciplinary comparative analysis, this book on the law of emergency powers holistically analyzes emergency powers under the constitutions of three democratic common law jurisdictions. Over the span of five chapters, the authors successfully aim at exploring the genesis of emergency powers philosophically in various civilizations, international instances of the armed forces aiding civil authorities, and the permissibility of exercising martial law powers under the Indian Constitution. Tracing the development of emergency powers since the time of British rule and the two world wars, the authors explore Constituent Assembly debates and the contentious 42nd and 44th Amendments to the Indian Constitution. They specifically deal with the often misused provisions for imposing President's rule under Article 356 and the possible challenges and impacts on judicial independence of the invocation of a financial emergency under Article 360. This book has come out at a very opportune time in our nation's legal and political history. As we come close to completing 75 years of independence and mark the 44th anniversary of the impactful 44th Amendment to our Constitution, it is time to stop, look back, and ponder over the transformative document which we as a nation gave to ourselves in the year 1950. The Constitution of India, like many other constitutions, can be understood as a system of norms given by a body politic to itself. Like many other instruments, it is premised on certain normal behaviors and historical circumstances, which, if applied to extraordinary or supernormal events, might produce unpredictable and undesirable results. Imagine a war where troops need to be enlisted and deployed rapidly, or the case of a pandemic which requires quick preemptive travel restrictions. The normal deliberative process of democracy is slow, and in trying to accommodate the rights of every citizen, the constitutional system and perhaps the entire population itself might be lost. As highlighted in the fifth chapter by the authors, the tendency of modern institutions to divide power as a check against despotism can indeed lead to paralysis. Therefore, most of the nation's constitutions contain either written or implied emergency provisions which provide for an alternative framework for more decisive governance in such exceptional times. Interestingly, there are hardly a few countries, and indeed no mature democracy, which has invoked such powers since the turn of the 21st century. Despite war, plagues, revolution, secessionist struggles, and even economic crisis, India, for example, has never imposed a nationwide emergency after 1975. Many would even say that Article 352 is now a matter of constitutional history and not a live or active instrument. Perhaps it is because the political consequences and international ramifications for an improper invocation of such powers is larger than the benefits drawn out of it. It is worth noticing that the world today is a fundamentally different place than a century ago. Since the Second World War, most of the nation states have broadly remained the same. International boundaries have not been largely altered, and the cost of colonization or conquest is not easily affordable. Countries no longer declare war formally, and it is safe to say that survival is no longer the primary concern for national governments. The focus has rather shifted largely to two bigger challenges, namely domestic unrest and terrorism. This may look frightening, but it certainly doesn't threaten the existence of national institutions of democracy. In fact, there has been a steady movement towards using ordinary legislation and delegated powers to deal with these two new challenges. This is most visible in the times of the present coronavirus pandemic, where no nation has abrogated the constitution or invoked a formal state of emergency. In India, the Disaster Management Act and the Epidemics Act have been operationalized, and organs of the government have worked in tandem. It is perhaps because of this cooperation between the Union and the states that the virus is under check in our country. There is also a growing tendency that the issues of domestic unrest and terrorism ought to be handled without invoking the constitutional emergency powers. There has, in fact, been a gradual crossover where various jurisdictions have permanently incorporated harsh provisions within the normal framework of legislative powers so as to deal with such threats. It can be seen in the examples of the Patriot Act in the US, Defense Against Terrorism Act in UK, and the TADA UAPA or POTA in India. The amount of delegation of powers to the executive under these statutes is indeed a matter of concern, as it creates a situation rife for arbitrary exercise of powers, which consequently endangers individual liberty and human rights. It also goes without saying that the very existence of emergency provisions in democracies adhering to the rule of law might be an antithesis to the constitutionally guaranteed rights. Nevertheless, incorporation of such provisions may be necessary to address the extraordinary situations. However, it is equally necessary to prevent the abuse of these provisions, be that may contained in a constitution or in a statute. Such a remedy undoubtedly lies in the overwhelming and extraordinary power of judicial review vested in every jurisdictional judicial system. It is in this background that the true importance of Dr. Singhvi and Professor Gautam's book emerges. I have had the fortune of receiving an early copy and have skimmed through some parts of it. The authors do not shy away from contentious issues and provide thought-provoking insight into questions like whether emergency can be declared under Article 34 of the Indian Constitution, even if FFCPA constitutes martial law, and what would be the contents of a financial emergency if ever declared. The book provides an array of solutions for lawmakers, legal administrators, and other stakeholders on the strength of comparative analysis of the experiences of the world's largest and oldest democracies. Law as a discipline is vast and amorphous. By adopting an interdisciplinary approach of reading history, political theory, and philosophy conjointly with the law, the authors have very eloquently provided varying perspectives on the law of emergency powers. The book is not a descriptive legal commentary. It does not only answer the what, but it also the why, when, and how of the evolution of emergency powers. It also bears the true hallmark of wisdom and maturity. The authors accept at places the lack of clear answers and acknowledge that a certain uncertainty is inherent in law. And I'm sure this would encourage further research and reshaping of modern emergency powers. Lastly, with this book in my hand, I assure Dr. Singhvi that lakhs of lawyers across the bar and the bench would concur with his respected mother's opinion that his doctorate was not the valuable time lost from legal practice. I also congratulate Professor Gautam for conducting a brilliant review of the book and producing a marvelous research at such a young age. Thank you very much. Jai Hind.
Thank you very much, sir, for the very inspiring set of reflections about the book and indeed your own perspective when it comes to the importance of the book and the timely publication of this by both Abhishek as well as Kagesh. Before I invite our next guest of honor, allow me to share with you this very special comment from Honorable Justice R.C. Lahoti, former Chief Justice of India. He said, and I quote, "This work provides the first comprehensive analysis supported by rigorous research and intellectual discipline of concepts in emergency law that have not been addressed in this manner before in India. Many questions heretofore unanswered and urgently needing an answer have been addressed and, in my opinion, have been laid to rest in this work of unparalleled scholarship," unquote. This book will indeed be the answer to the questions the world of law is in dire need of in these times. Let me have the distinct pleasure of inviting Honorable Mr. Justice Sanjay Kishan Kaul, Judge, Supreme Court of India, to honor us with this special address. One of the best legal minds of our nation. He's currently a judge of the Supreme Court of India and has practiced mainly in commercial, civil writ, original and company jurisdiction of the High Court of Delhi and the Supreme Court of India. He later moved to being the additional judge of the High Court of Delhi in 2001. And was appointed as a permanent judge in 2003. Justice Kaul was subsequently elevated as the Chief Justice of the Punjab and Haryana High Court and then assumed charge as the Chief Justice of the Madras High Court. He brings with him a great academic lineage, having studied in economics honors from the University of Delhi in St. Stephen's College and to earning his law degree from the Campus Law Center Faculty of Law, University of Delhi. With those words, let me have the pleasure of inviting Honorable Mr. Justice Sanjay Kishan Kaul to deliver his address.
Justice Ramana, Justice Chandrachud in absentia at the moment, Justice Suryakant, my classmate Dr Abhishek Singhvi, Professor Dr C. Raj Kumar, founding Vice Chancellor of the OP Jindal University, Professor Kagesh Gautam, Associate Professor of the same institute, ladies and gentlemen. It gives me great pleasure to join in this august gathering for release of the book, The Law of Emergency Powers, Comparative Common Law Perspective, authored by the two authors. The commitment of Dr. Singhvi to constitutional values is well known, and I attribute my presence to that today. He didn't want to violate Article 14 of the Constitution of India, having invited one of his classmates, Justice Chandrachud, for this webinar, and therefore I am the second one to join that occasion. Well, on a more serious note, academic legal writing, I think, is an important aspect of inputs for jurisprudential development in a vast number of countries. This is some area where we have been lacking for a long period of time. Judges must get inputs, critiques of what they write, but not affected by a particular political or other viewpoint, certainly a jurisprudential point. Now, that itself helps in developing that particular jurisprudence. And the seed for the problem, as Dr. Singhvi said, was the not so great aspect of the number of law schools we have with the quality suffering in the bargain. So it was to my mortification that I came to know as Chief Justice of the Madras High Court that just visiting across the road, one of the khokas where the stenotypist used to sit could be good enough to get you an enrollment in a university outside the territory of Tamil Nadu and get you a degree after having paid your fees without troubling your mind with law. These are ground reality situations. And I think they are the crying need to see how we can improve the legal education. I do believe that we are churning out too many lawyers without any analysis of the number of lawyers required. For example, the chartered accountancy profession, which does that. And so a lot of thought process is required for it. As we see today now, we are perhaps more familiar than ever as to what it means to live outside the normal and are possibly better equipped to appreciate the effect of a fear-ridden global presence. Simply put, emergency powers seek to widen the scope of the ordinary power of a government, which might be insufficient in times of crisis. The legal regimes for emergencies, constitutional limits combined with statutory powers, are key to ascertaining whether the state of emergency will prove to be a threat to the constitutionalism or measure to restore stability and constitutional order. A difficult balance. Towering this fine line, therefore, brings to the fore critical questions on the rule of law, the separation of power, and the independence of the institutions. The test, perhaps, of any legal system of constitutional democracy, therefore, lies in addressing the fundamental tension that exists between the basic premise of the government constrained by law and the perceived need for unfettered discretionary power to confer the state of emergency. Dr. Singhvi and Professor Kagesh books studies emergency powers under three different jurisdictions: UK, USA, and India. Together, the three jurisdictions represent a variety of constitutional models and cover perhaps the largest population under common law systems. Unique political and legal traditions have shaped the exercise of emergency powers in each of these countries and the role of the courts therein. For instance, while the Indian Constitution devotes the entire chapter to emergency powers, no such powers are expressly provided for the Constitution of the USA. In the UK, the exercise of emergency powers are, in exceptional circumstances, rarely denied, even though they lack a written constitution. The role of courts in these disparate legal contexts is fascinating and makes for meaningful study, as a comparative analysis offers important domestic and cross-jurisdictional lessons in use and abuse of emergency powers. Of equally sound selection are themes addressed in the book, raising important legal questions of great contemporary relevance. The very invocation of martial law, for example, has been a vexed question across all three jurisdictions. When does it become necessary to impose martial law, and who decides that martial law is necessary? Similarly, in exploring the phenomena of a military acting in aid of a civilian authority, a concept that has received more judicial attention in the UK and USA than in India, the authors raise important questions about its overlap with martial law and how courts should construe statutes authorizing the exercise of military power over civilians in time of peace. A particularly interesting chapter in the book is devoted to understanding judicial independence and economic emergency in India, where authors have interrogated the conflict between judicial independence and the executive power in reducing judicial salaries during an economic emergency. The book concludes by bringing the discussion back home. The emergency provisions enshrined in the Indian Constitution in Part 18 were topic for strenuous discussion in the Constituent Assembly, where the focus was to understand the ramification of these provisions vis-a-vis the uniquely flexible Indian federalism. The lively debate from both ends resulted in introduction of several safeguards into the emergency provisions in order to minimize instances of abuse. It led to reconciliation of two extremely important approaches to emergency powers in a bid to ensure that the center is able to function swiftly and smoothly to address the cause of the emergency, while ensuring that its power cannot be trampled on the rights of the Indian citizens. Despite this, sadly, it did not succeed in providing the right checks and balances at a crucial time in 1975. While Article 352, 354 to 358 to 360 relate to the national emergencies, a different set of emergency powers are enshrined in Article 356 and 357, which refer to state emergencies. When the latter were presented to the assemblies, they were severely criticized for presenting a grave threat to the provisional autonomy. In testament to this, Article 356 has indeed witnessed a litigious past which has centered around a larger question of a separation of powers and judicial review. An authoritative answer was provided in the landmark case of S.R. Bommai v. India, where 9 judges bench held that the advice given to the President by his Council of Ministers, on which his satisfaction was amenable to judicial review. Bombay cemented a clear standard of judicial review and provided a check on the powers of the executive, even during the emergency. Mumbai marks one of the greatest contributions to the global emergency jurisprudence and certainly contributed to the decline in the number of proclamations of state emergency thereafter, which has been very insightfully analyzed by Dr. Singhvi and Professor Gautam. The provision of national emergency also saw significant change pursuant to the 1975 emergency. The wave of detentions at this time finally reached the Supreme Court in ADM Jabalpur versus Shivkant Shukla, where by a majority of 4-1, the bench ruled in favor of the state and allowed Article 359 to have a blanket preclusive effect on judicial review. But like a lamp in this darkness, the brilliant and courageous dissent of Justice Khanna cogently held the life and liberty of individuals could not be at the mercy of the executive, even at the time of the emergency. The judicial error in ADM Jabalpur was recently corrected in Puttaswamy versus Union of India, where the same was categorically overruled. Puttaswamy recognized that certain basic rights were recognized by the Constitution and were not conferred by it. Thus, the Constitution did not form the sole repository of the right of citizens. These rights were inalienable and inherent in all human beings simply by virtue of their being human and thus could not be suspended. Despite these developments towards strengthening our democracy by providing more safeguards into the emergency provisions, it remains critical that we as a society and a polity remain cautious of taking the same unfortunate road again. The threat that looms large across the globe is the possibility of triggering emergency-like situations in de facto manner without actually taking aid of the emergency provisions explicitly. The pandemic has provided one such vantage point to look at this aspect. The balance between the attending to a public health emergency of this magnitude and respecting the rule of law has been carefully maintained. The recent developments in one of established democracies itself is a proof of what can go wrong. But fortunately, saner thinking hems in the possibility of something which would go out of hand. Unprecedented scenarios like these also present before us an unprecedented academic and practical questions to grapple with, which endeavor has of course been deftly taken up by the authors of this book. At the time when a mere biological survival appears to have been trumped moral, and I use the trumped word in the colloquial sense, and social relations, this study, placing emergency powers in the historical context, is a sobering reminder of the many legal, political, and philosophical implications any extraordinary state of being entails. The long future will, of course, tell us how we have fared in these times, but scholarly contributions such as this book provide the benefit of invaluable foresight and analysis directed towards keeping the letter and spirit of the Constitution alive. As Lord Atkin had most succinctly put it, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. On the use of the expression prolegomena instead of a preface, I can only tell Dr. Singhvi he seems to be inspired by a senior of our college and his a political mate in his party, who is well known for it. I congratulate the authors on this timely and substantial inquiry into the law of emergency powers, which will enable readers to understand the particular experiences of emergency and see them in a broader interjurisdictional context. It is indeed heartening to see what started out as Dr. Singhvi's doctoral thesis has come to fruition with the able co-authorship of Professor Gautam. I also extend my warmest compliments to the publishers for bringing this work to life. And finally, I would like to congratulate and applaud OP Jindal University and Professor Raj Kumar for providing valuable institutional support to this undertaking. The legal field and the study of law are richer by it. Thank you.
Thank you very much, Justice Kaul, for that absolutely inspiring address. And I really appreciate the fact that you took effort to not only reflect on some of the key features of the book, but also paid a tribute to your classmate and, of course, co-author of the book. As I had mentioned earlier, this book has already received a number of accolades from leaders and stalwarts across the legal fraternity and academia. Allow me to share one more such excerpt by one of the leading leaders in the world of legal education, as well as research professor, Dr. Upendra Baxi, who is currently professor of law at Jindal Global Law School at OP Jindal Global University and emeritus professor of law, University of Warwick, and former Vice Chancellor, University of Delhi. And Professor Baxi says, and I quote, "This work by Dr. Abhishek Singhvi and Professor Kagesh Gautam offers a provocative treatise on emergency powers in the Constitution of India. It bristles with comprehensive historical narratives and contemporary insights and helps us better understand the location and the vocation of authoritarian power to sustain as well as destroy the letter and the spirit of a living constitutionalism," unquote. I am sure that this book will result in a lot of thought-provoking actions, which are indeed the need of the hour today. Let me have the pleasure to invite Honorable Dr. Justice D.Y. Chandrachud to honor us with a special address. One of the leading stalwarts in the world of law. He has made instrumental changes as judge in the Supreme Court of India. He's also practiced as an advocate in the Supreme Court and the High Courts of Gujarat, Calcutta, Allahabad, Madhya Pradesh, and Delhi. He was designated as senior advocate by the Bombay High Court in 1998. He served as the additional Solicitor General of India from 1998 to 2000. In 2000, he was appointed as an additional judge of the Bombay High Court. He took oath as Chief Justice of Allahabad High Court in 2013, a distinguished alum of the Harvard Law School, where he completed his LLM and STD. He indeed represents one of the finest judicial minds of India and the world. Let me invite Dr. Justice Chandrachud to deliver his address.
Good evening, everyone. My very distinguished colleague, Justice N.V. Ramana, my distinguished colleagues, Justice Sanjay Kaul, Justice Suryakant, Dr. Singhvi, Professor Dr. C. Raj Kumar, and all the other dignitaries who are present. I'm personally delighted to be participating at the virtual inauguration of Dr. Abhishek Singhvi's and Professor Kagesh Gautam's seminal work on the law of emergency powers. I think by inviting both Justice Kaul and me to this event this evening, Dr. Singhvi has run a dual risk of inviting two batchmates from the old days at St. Stephen's College. I wouldn't say St. Stephen's College and Campus Law Center, because Dr. Singhvi broke the ranks when we were students at the Campus Law Center and went to Cambridge to pursue his legal education. But he runs the risk on two counts. I believe that by inviting two batchmates, he submits to a decree on admission. That's one. And then the second risk which he does submit himself to is to an attachment before judgment. With those prefatory caveats to the distinguished author, let me begin what I have to say this evening. The timing for the release of this book is really most opportune, as just last year, as many as 13 nations formally declared a national emergency alongside other nations, where the executive adopted exceptional powers to tackle the COVID-19 pandemic. So comparative study of emergency powers is the best resource for anybody seeking to contextualize their social citizenship in these exceptional times that we today live in. I've had the opportunity to course through the book, and I was deeply impressed by the depth and the breadth of this academic endeavor. I extend my congratulations to Dr. Singhvi and to Professor Kagesh Gautam for their laborious cross-jurisdictional analysis. In my reading of the prolegomena by Dr. Singhvi, I must acknowledge the invaluable contribution by his spouse, Anita Singhvi, for providing the critical support that enabled the blueprint of his work to be first produced as Dr. Singhvi's doctoral dissertation at Cambridge. But I think equally, one must also pay a tribute to his distinguished parents, Dr. L.M. Singhvi, a doyen of our bar, and whose contribution of the Gandhi statue adorns the lawns of the Supreme Court. Distinguished parliamentarian, academician, lawyer, jurist, whom we as young students knew so personally. And of course, Dr. Singhvi's mother, Kamlaji Singhvi, who has been a source of immense strength, guidance, and affection for the family. So much as we praise Dr. Singhvi, we also pay a tribute to the two very significant parents, Dr. Singhvi, L.M. Singhvi, and his own mother, who we know have played an enormous role in shaping the course of his own career, and with whom we were very privileged to know to personally as young students. Much like Dr. Singhvi reading for his thesis in the 1980s, even my transformative years as a student were deeply impacted by the 21-month-long emergency between 1975 and 1977. Ours was the first batch, the first emergency batch in the Delhi University. And one of the consequences which emanated from that was that the ragging which we had to undergo in Delhi University at that time was rather meager as compared to the wilder traditions of the university which we had come to occupy as students. But apart from that, we were witness at first hand, as we would take our university specials, of the indoctrination of our minds which took place through the placards of the 20-point program, driving from Central Secretariat in the 210 or 220 onto Delhi University. We were in those days personally privy to the speeches which were delivered by some of the most leading examples and those who were crusaders in support of personal liberty, some of whom are fortunately present today, some of whom have passed away due to the tragedies of destiny. The unprecedented destruction of civil liberties in the garb of curbing an internal disturbance serve as harrowing reminders of state excess. As a young student whose father was on the bench, I gained a vicarious personal insight into the tribulations of a judge who was grappling with his reconfigured role in this novel state of exception. History is replete with instances of civil liberties being the collateral damage of a national emergency. ADM Jabalpur was one of those in our tradition. But ADM Jabalpur is not a standout feature of international jurisprudence. Justice Frankfurter, in his concurring opinion in Korematsu versus the United States, upheld the internment of Japanese Americans, American citizens of Japanese ancestry during the World War II by stating that, and he said, to recognize that military orders are reasonably expedient military precautions in the times of war, and yet to deny them constitutional legitimacy makes of the Constitution an instrument for dialectic subtleties, not reasonably to be attributed to the hard-headed framers, of whom a majority had had actual participation in the war. Around the same time, you had the famous dictum of Lord Atkin in Liversidge versus Anderson, which Justice Kaul just referred to, where he famously dissented against the overbroad powers of detention by noting that amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. Fortunately, international jurisprudence has found favor with Lord Atkin's approach and cultivated a deeper respect for human rights and civil liberties. Much has been written about this dark hour of Indian democracy and its shadow on the judiciary, the emergency of the 1970s. Dr. Singhvi's book weaves a fine thread across legal principles, state philosophy, and the political reality of the time to provide a nuanced perspective to its readers. I was particularly interested by its mentioning of several High Court decisions that attempted to sustain judicial review during the real politic. And I compliment Dr. Singhvi for that, because I do believe that staying in Delhi, you have an excessively Delhi-centric view of the Indian polity. And particularly living in Delhi, we tend to presume that the entire universe of law is consumed by the Supreme Court of India, not realizing that the real law is developed in the district courts and in the high courts of the nation. And it was our high courts, including the judgment of the Madhya Pradesh High Court in ADM Jabalpur, judges like Justice A.P. Sen, Justice Tulsapurkar, Justice Chinnappa Reddy, and a whole number of judges, many judges who were transferred as a result of their judgments in the high courts during the emergency, which stand out in terms of the contributions they made and which find recognition in this book. The comparative analysis on martial law and the arguments for sustaining independence of the judiciary are thought-provoking indeed. The Indian emergency of 1975 began with the executive assuming enhanced powers to counter the threat of internal disturbance, as was then provided by Article 352. This enabled oppressive norms of preventive detention and pre-publication censorship. As a consequence, our constitutional doctrines went through one of their deepest phases of introspection and reclamation, particularly those that interpreted the scope and nature of judicial review over the state's temporary exceptional powers. I believe that a seminal contribution of this book to existing scholarship is reflected by its analysis of these verdicts, not just from the lens of Constituent Assembly debates, but through its tracing of a historical evolution of state power dating back to colonial times and the pre-colonial Indian subcontinent. The COVID-19 pandemic, one of the largest global disruptors in over a century, will probably be one of the deep influences on the scholars of today. Fervent and frequent lockdowns, restriction of movement, enhanced powers of the executive were a pervasive phenomenon necessary to tailor state infrastructure to battle a deadly virus. In the face of mortality, one couldn't simply argue for their fundamental right to travel freely. Even if an emergency in the constitutional sense was not declared in India, several executive and legislative actions were initiated to meet the extraordinary challenge of our times. The judiciary, as a counter-majoritarian institution, in times of such state crisis, has to adopt a much finer line of judicial review over executive action that is dealing with medical novelties to preserve public health. An oft-cited example is elucidated by the judgment of the US Supreme Court in Jacobson versus Massachusetts, which comes to mind. The court was dealing with constitutional concerns over the compulsory vaccination to contain the outbreak of a smallpox epidemic in 1905. The US Supreme Court assessed its role by holding that their constitution principally entrusts the safety and the health of the people to the politically accountable officials of the states to guard and protect. Justice Harlan had famously balanced the individual's liberty with the community goals of public health when he stated that there is, of course, a sphere within which the individual may assert the supremacy of his own will and rightfully dispute the authority of any human government, especially of any free government existing under a written constitution. But it is equally true that in every well-ordered society charged with the duty of conserving the safety of its members, the rights of the individual in respect of his liberty may at times, under the pressure of great dangers, be subjected to such restraint to be enforced by reasonable regulations as the safety of the general public may demand. Constitutional law has made progression since then, including by the advent of the doctrine of proportionality. This principle has evolved and has been put to test in its contemporaneous forms as the judiciary dealt with claims of individuals and groups whose rights were impacted by state measures. The Supreme Court of the United States considered the constitutionality of the COVID-19 pandemic restrictions in California, in Nevada, on issues such as the seating capacity at church congregations. It balanced the competing consideration of the free exercise clause under the First Amendment to the US Constitution in favor of executive action, and held that the precise question of when restrictions on particular social activities should be lifted during the pandemic is a dynamic and fact-intensive matter subject to reasonable disagreement and entrusted with the politically accountable officials. In the United Kingdom, the Court of Appeals, in a judgment in 2020, upheld the relaxation of the Abortion Act to enable access to abortion pills at home. It noted the legislative intent of securing safe abortions for women in the Abortion Act and held that the relaxation in favor of an online prescription was to address a specific and acute medical need in the context of a public health emergency so as to ensure the continuance of the protection of the health of women. The Supreme Court of New South Wales in Australia had to consider, likewise in 2020, the claims of freedom of assembly during the pandemic in denying certain notices of intention to hold a public assembly over issues such as refugee actions and the Black Lives Matter movement. The court mentioned that the balance of these considerations will necessarily shift over time, having regard to the changing public health risks. It would be trite to say that governments had to make choices across the world at very short notice on the basis of social, political, economic, and budgetary considerations, while striking the right balance between these competing considerations. The judiciary had to inevitably provide a wider margin for government action that sought to adapt a public health crisis. However, this state of exception and public health emergency is not to jettison all methods of constitutional scrutiny. It is incumbent upon the courts to ensure, at the very least, that the state action is a rational means for securing a legitimate aim with the least infringement on the rights of an individual. In my experience at the bench during the pandemic, I had to personally encounter one such case where the state of Gujarat employed its exceptional powers under the Factories Act of 1948 to curtail significant worker protections such as overtime pay by elevating the coronavirus pandemic as a public emergency that was statutorily defined by the Factories Act. The state sought to justify its invocation, citing the economic harm caused by the pandemic. It argued that limiting working conditions and overtime pay was necessary to meet the minimum production targets that were impacted by the lockdown. In analyzing proportionality of these measures to the slated goal, my brother judge and I had to deep dive into the constitutional underpinnings of the concept of emergency and the redemptive constitutional amendments thereafter. We found that the narrowing of these powers was to disable an amalgam of uncontrollable power and unbridled discretion that provided fertile grounds for the destruction of liberty. We eventually held that the declaration of a public emergency under the Factories Act 1948 is qualified by strict statutorily prescribed eventualities that gravely threaten the security of the state. The concept of internal disturbance had to be reinterpreted from the constitutional lessons of the 1975 emergency. I had to draw on the work of several academic scholars in interpreting the constitutionality of measures that are typically provided greater leeway during a public emergency. I would have greatly benefited from the book, which is now being published, on its historical and contemporaneous analysis on emergency powers, were we to write now. A jurist par excellence, Simeon E. Baldwin, described the role of lawyers in the common law by saying, the development of law is primarily the work of the lawyer. It is the adoption by the judge of what is proposed at the bar. I would like to add my own observation to this sentiment and say that the work of the bar is aided and propelled by the thought of the scholar and the academic. And I think that is the contribution of this book to the jurisprudence on the subject. Carl Schmitt, a conservative and political theorist in the Nazi regime, had described the sovereign as the one who decides on the exception and argued for a state of emergency to justify unilateral state power that is not meant to be circumscribed by a pre-reformed law. Our framers consciously moved against a construction that would enable an easy acquisition over state machineries and over a facetious claim of an emergency. I heartily congratulate Dr. Abhishek Singhvi and Professor Kagesh Gautam for their scholarly expedition, which provides a comprehensive framework to navigate the constitutional contours of a state of exception. This academic endeavor in the evolution of constitutional doctrine would play a critical role in averting the snowball destruction of democratic institutions, which is often birthed from a state of emergency. It provides a critical reflection of what has happened in the past so that we as citizens remain alive to the dangers of growing executive powers every day of our lives. Thank you very much for inviting me, and I congratulate you for this beautiful contribution to the subject. Thank you.
Thank you very much, Dr. Justice Chandrachud, for again a fascinating and inspiring tour de force on the evolution of the law of emergency in India, but also in other jurisdictions. I also deeply appreciate the fact that you cited some of the emerging jurisprudence from different parts of the world, and the finest developments in comparative constitutional law is being reflected through the work of Dr. Singhvi and Professor Gautam. We now come to the very important part of this evening. Of course, it's quite a unique situation where we are actually trying to do this book launch in the way we are doing. So I'm going to request Honorable Mr. Justice N.V. Ramana, Judge of the Supreme Court of India, to formally release the book, and the act of release will effectively constitute all of us holding the book. So I'm going to request all of us, to hold the book while Honorable Justice Ramana is releasing the book. Thank you very much. This is indeed a very special moment, and I deeply appreciate your indulgence in this. As we, of course, release the book, I would like to take this moment to summarize the essence of this book by a very distinguished jurist by name Professor David Wilkins, Leicester Kissinger Professor of Law and Vice Dean of Global Initiatives and Legal Profession, and Faculty Director of the Center of the Legal Profession at Harvard Law School in the United States. And I quote, "In this timely and important book, Abhishek Singhvi and Kagesh Gautam trace the history and contemporary uses of one of the most consequential and controversial actions that can be taken by any government to declare a state of emergency. With all of the analytical rigor and theoretical sophistication that one would expect from a book written by one of India's leading advocates and an equally distinguished scholar, the authors catalog and dissect the justifications that have been offered for this extraordinary suspension of the normal rules of governance from ancient Greece to the Indian Constitution," unquote. And now it is time for me to extend a warm welcome to our distinguished chief guest, renowned for his legal reforms and representative of the most intellectual legal minds of our nation. I have great pleasure to invite Honorable Mr. Justice N.V. Ramana, Judge of the Supreme Court of India, to commemorate this very special moment. He comes with years of experience and knowledge. He has practiced in the Andhra Pradesh High Court and Central Administrative Tribunals and the Supreme Court, specializing in constitutional, criminal, service, and interstate river laws. He served as additional standing counsel for the central government and standing counsel for railways in the Central Administrative Tribunal. He also served as additional advocate general of the state of Andhra Pradesh and as the president of the Andhra Pradesh Judicial Academy. In 2000, he was appointed as a permanent judge of the Andhra Pradesh High Court. He was later appointed as the Chief Justice of Delhi High Court in the year 2013. On a more personal note, I've had the privilege to interact with him, and I've always struck by simplicity, humility, and self-effacing nature. With those words, let me request Honorable Mr. Justice Ramana to deliver his address.
Good evening to everybody. Honorable Dr. Justice Chandrachud, my brother, Honorable Justice Sanjay Kishan Kaul, Honorable Justice Suryakant, Dr. Abhishek Singhvi, Senior Advocate, Supreme Court and Member of Parliament, Professor VC Raj Kumar, Founding Vice Chancellor of Jindal Global University, Professor Kagesh Gautam, Associate Professor and co-author of this book, and Ms. Nupur Singh, Editor of the Springer Nature, and advocates, media persons, ladies and gentlemen. I had the opportunity to go through this wonderful book on the law of emergency powers over the last weekend. I must say that the authors have turned a very complex and understudied area of law into a delightful, simple, and easy comprehend work. However, before I start my speech as a judge, I have to place a caveat. I require to be a little more circumspect while discussing my thoughts on a legal subject, which is this, where the law is not so well settled and is contestable. Before going to the topic, while in the speeches, Dr. Singhvi as well as Justice Kaul has expressed their concern about the mushrooming law colleges and standards of legal education in this country. I welcome this thought-provoking discussion, and I agree with what they expressed. It requires an immediate, urgent reform. And in fact, Justice Kaul used to complain when he's working in Chennai as a Chief Justice that how these law colleges from the neighboring state, and particularly my state, were in a car shed and a apartment, they started colleges and giving certificates. Now this is the time, and that too, senior advocate of the Supreme Court bar is showing so much concern. I express and I hope that we can take up this issue in the coming days. Now coming back to the book. At the outset, regarding this book, brought back my memories of national emergency of 1975. In 1975, I was a young student of 18 years, having great hope and optimism. Looking back, I feel surprised at my own audacity and will. As the saying goes, if you, at the age of 20, you are not a communist, then you have no heart. If at the age of 30, you are not a capitalist, then you have no brains. On 25th June 1975, a public meeting was organized in my hometown on civil liberties. Actually, I am the presiding person of that meeting. I was about to step out of my house to join when my father told me, pack an extra pair of clothes, because he was convinced that I would be arrested during the function. Getting closer to the venue, I observed that people were running in panic. One of my close friends on the way, who is no more unfortunately, came running and informed that the police were arresting people. He took me to the outskirts, informed me about the government is going to proclaim emergency, and we both taken a lorry and traveled 2-3 hours in the lorry, and then walked all night to reach my maternal aunt's house with 10 rupees in my hand. In the hindsight, maybe my father should have given some more extra money. Emergencies have long-lasting impact on generations. In my case, a year of academic studies and mental suffering can be attributed to the emergency. But I have no regrets. I have seen so many young people sacrificing their lives for the sake of human rights. I met people with several ideologies. I learned so much during the year about human tragedy, hunger, pain, and suffering. Our experience of this time brought forth the importance of understanding the concept of emergency. Questions such as what such a declaration connotes, when can it be legally proclaimed, and what the permissible actions during an emergency are. It is these questions, among others, that the book tries to address by doing a cross-jurisdictional study. This book had its origin in Cambridge in the year 1980, when Dr. Singhvi worked on his PhD thesis under the tutelage of Professor William Wade, a renowned scholar of administrative law. Dr. Singhvi states in the book that while he was initially determined to develop his thesis on due process, after much research and deliberation, he ultimately decided to explore the area of suspension of due process. I am sure I am not alone in feeling that this was an inspired decision. Although I am certain that Dr. Singhvi, with his sharp analytical skills, would have produced an important treatise on the interpretation of the idea of due process, it would have resulted in a great loss to the legal world. The lack of scholarship in this area should not be confused with its relative importance. A mere glimpse at the table of contents of the present book indicates the breadth of possible study relating to the concept of emergency powers, while the different chapters bring to the fore the depth of the study undertaken. This puts into perspective the full extent of the labor of love undertaken by the others in putting together this work. We need to remember the contribution of Mrs. Anita Singhvi, without whose support this book may not have been materialized. Coming to the book itself, it has divided into 5 chapters wherein the authors undertake a comprehensive legal and constitutional study of emergency powers across the jurisdictions of USA, UK, and India. The first chapter deals with the concept of emergency powers and its need, whether perceived or actual. Delving into the domain of legal and political philosophy, the authors suggest that the phrase emergency powers is ordinarily used in the context of a suspension of or departure from legal normality in response to a political, economic, or social crisis. To this definition, recent event and the future might necessitate the addition of environmental or natural crisis as well. The chief idea behind the concept of emergency powers in the preservation of the state. Human foresight, with its inherent limitations, cannot possibly be prepared to deal with all kinds of crises in such times in the interest of the state. Certain ideals underlying the state might have to be foregone temporarily. The others have aptly quoted Abraham Lincoln, who was very consciously captured this by saying, by general law, life and limb must be protected, yet often a limb must be amputated to save a life. But life is never wisely given to save a limb, unquote. The development of above ideas surrounding emergency powers and their application in the ancient world, from Greece and the Roman Empire to ancient in medieval India, from Plato and Aristotle to Machiavelli and to Kautilya, and even the Vedas, the others have expertly outlined the views held historically regarding emergency powers and the fact that some of the most revered philosophers of the ancient world have stressed upon the necessity of flexible system of administration to counter any emergent situation. The next chapter of the book deals with the subject of law of emergency pertaining to martial law. The authors define martial law is as one that is evoked as a last resort, generally in the face of war or civil strife, when civilian authorities and the courts are unable to function, thereby necessitating the military authorities to step in. After framing the concept of military law, martial law, in the above terms, the authors embark on a cross-jurisdictional analysis of martial law under the Constitution of the United States. The common law in the United Kingdom and the Indian, which is as enjoyable to read as it is illuminating. I found the questions raised by the others in the last section of the chapter pertaining to the Indian constitutional position regarding the proclamation of martial law, particularly throughout, is a thought-provoking. The third chapter relates to the allied concepts of the military acting in aid of the civil authority as compared to the situation described in the prior chapters when the civil authorities is unable to function. This chapter mainly deals with jurisprudence from the United States and the United Kingdom, and not much is written in connection with India. This is because, as the authors themselves explained towards the end of the chapter, post-independence, India has not had diverse examples of the military acting in aid of civilian authority. The fourth chapter of the book, which I believe is the brainchild of Professor Gautam, deals with the topic of economic emergency, which has not received much scholarly attention. Even more novel is the possible issue highlighted in the chapter regarding the judicial independence during such times. The others have enhanced the nature of the debate surrounding the question of emergency powers and have added a new dimension to it. The final chapter pertains to an in-depth analysis of emergency powers in India. It is in this chapter that the others embark upon an analysis of Part 18 of the Indian Constitution, which is titled Emergency Provisions. Though a study of the Constitutional Assembly debates the language of the constitutional articles, the exercise of these powers in independent India, as well as an analysis of the case law, the authors have contributed immensely by creating a comprehensive picture of the law surrounding this part of the Constitution and raise many important jurisprudential questions. Without saying too much on this topic, I would just like to point out a few things that struck me while reading the book. Of the three jurisdictions the present work discusses, it is telling that only our Constitution explicitly provides for situation of emergency. This is in part due to the historical conditions in which Indian Constitution was being framed, as well as the foresight and understanding of the framers of our Constitution. They took into account the teachings of the past and the uncertainties of the future in drafting the part of the Constitution which deals with emergency provisions. As was observed by some of the members of the Constituent Assembly, such provisions are necessary evils aimed at resolving crises identified under the Constitution. In such circumstances, when the very state is at risk, some ideal may have to be sacrificed, but only in line with the Constitution. Supreme Court of India has in the center of this discussion, from A.K. Gopalan to ADM Jabalpur, to Maneka Gandhi to Puttaswamy, is a complicated journey, which this book explains in a simple manner. From the opinion of ADM Jabalpur to Brother Justice Chandrachud's opinion in Puttaswamy, the growth of jurisprudence is historic. Finally, I would like to thank the others for bringing back my memories through their incredible work of scholarship, which I am certain will be of great assistance to academicians, practitioners, judges, students of law, and any and all interested in the topic. This book has the distinction of not only being extremely informative, but also have been written in a clear and engaging manner, unlike most books pertaining to the law that I have come across. For that alone, the others deserve all the praise and appreciation. Thank you very much for giving me this opportunity.
Thank you very much, Honorable Justice Ramana, for again a fascinating address. I deeply appreciate the fact that you reflected upon your own past and the times when these issues were coming to the forefront at the early stages of that exercise of powers within India. I also appreciate the fact that you spoke about the importance of legal education reform and its own centrality when it comes to addressing issues relating to teaching and research within law schools. Before I call upon the next special speaker, allow me to share one more quote from a very distinguished jurist about the book itself, Honorable Justice M.N. Venkatacharya, former Chief Justice of India, writing about this book. He said, and I quote, "In this brilliant work, law of emergency powers, Dr. Abhishek Singhvi, who commands a large practice in constitutional and public law litigation in India, and a scholarly co-author Kagesh Gautam, dig into the depths of Constitution's dark matter, as he calls it, to trace emergency powers and the legal limits of the concept, unquote. On that note, I would like to invite Professor Kagesh Gautam, a very distinguished colleague, who has co-authored this very special book today, to share the concluding remarks. Professor Gautam is currently an associate professor at Jindal Global Law School of OP Jindal Global University, received his LLM from Columbia Law School. He also comes with a number of years of experience in the world of law. He was admitted to the Delhi Bar Council in 2008 and was an associate in the law firm of Desai and Divanji. After that, he transferred his bar membership to Punjab and Haryana Bar Council and practiced before the Punjab and Haryana High Court at Chandigarh. He specialized in indirect taxation, civil and criminal appellate, administrative and constitutional litigation, and appeared and assisted counsel in several cases before the High Court and taxation tribunals throughout Haryana, Punjab, and Himachal Pradesh. But I'm very happy to report that the loss of somebody like Kagesh to the bar and possibly the bench is indeed a great gain to academia. Professor Kagesh Gautam has been a distinguished scholar. He has widely published in journals around the world, including the Columbia Journal of Asian Law, Indiana Journal and Comparative Law Review, Southwestern Journal of International Law, Boston University International Law Journal, Vienna Journal on International Constitutional Law, Journal of Comparative Law, International Tax Journal, and indeed the Economic and Political Weekly. With those words, I would like to now invite Professor Kagesh Gautam to deliver the concluding remarks on this occasion.
Thank you, Raj, for that very kind introduction. I don't think I really deserve that, but to conclude the remarks of such an august panel that has spoken before me is a very challenging task. Let me begin by briefly thanking all the people without which this book would not have been possible. So first of all, of course, I'd like to thank Dr. Raj Kumar, who who came to me and said, look, this is the project, would you like to work on? Luckily, I was aware of the project and I was aware of the difficulties and the challenges it would present, but Raj backed the team, especially me, throughout, provided constant support, and for that I'm very thankful, Raj. I'd also like to thank Dr. Abhishek Singhvi, who provided me this opportunity. And as I've said in past, I think I could say this on record, that there seems to be some karmic bondage there, because the year this thesis was finished was the year I was born. So I don't know if this was fated or circumstances brought us together, but here we are, and now the book is out, and I hope the people, lawyers, judges, everybody who reads it finds the book useful. There is a lot of hard work, a lot of personal sacrifices that have been made to make this book happen. And I'm very grateful that I was given the opportunity to work on this book. And I think something useful has come out. And I do believe that something very useful has come out. I'd also like to thank my research assistant, Ronak Jaiswal, who is now a faculty member with us in Jindal Global Law School, who worked day and night tirelessly. And thanks, Ronak, for the effort. And of course, I'd like to thank my mother, my father, and my wife, last of all, Shelja, all of whom provided support, and they had their roles to play. But now coming to the remarks that have been made, I think I'd like to see the one thing that I learned working on this book, and that's a lesson that I've taken with me, is that working on emergency powers requires a special set of skills. It's not easy to work on. It's a very complicated area of law. And luckily, I had done just about enough work and had published just about enough for me to be able to work with Dr. Singhvi on this. But as I worked with him, I learned that any systematic study of emergency powers requires three things. And that's a very modest, a very humble suggestion on my part. I think it requires approach of a naturalist, with which I think Justice Dr. Chandrachud might agree. It, I think, requires the discipline of a positivist, with which I'm absolutely certain Justice Kaul will agree. And I think it requires the disposition of a realist, with which I think Justice Suryakant and Justice Ramana will agree. Now, Justice, in the beginning of this talk, in the beginning of this ceremony, Raj said that we are very thankful to the judges who came out of their busy schedule And of course, we are very grateful. But I think some of the things that Justice Suryakant said, and I noted them down. Justice Suryakant said this time is opportune to look back and ponder over. Now, I would say that we should be more proactive in inviting the judges to these ceremonies, because I think it will allow them a break from the dust and tumble of Tilak Marg, and to reflect on these questions in a more detached. I think perhaps the location of the university has something to do with it, because it's not too far away from Delhi. But once you get here, you feel a sense of separateness, and perhaps you can engage with deeper questions. So I think I'll take my cue from Justice Suryakant on that. And I would say we need to reflect on this. Now, Justice Chandrachud mentioned Korematsu. Though it is correct that in USA, Korematsu is one of those cases that Professor Jamal Green of Columbia Law School, in an article in Harvard Law Review, calls an anti-canon, a case that has not actually been overruled, but is looked at, and the canon of the law, the doctrine of the law, is then developed, making sure it's not resembling the case which is not yet overruled. It's a very important article. Korematsu continues to be the anti-canon. Remember, Korematsu has not been overruled. The second Korematsu judgment only overturned the conviction of John Korematsu. It didn't actually overrule it. Well, we have already overturned our own Korematsu, so that's there. But one of the things that has to be kept in mind are the reflections of Alexander Hamilton in Federalist number 23, which are quoted in the book, but I think it's very important to read them out here. Alexander Hamilton in Federalist number 23, reflecting exactly on the nature of emergency powers. Since we are talking about the jurisprudence of emergency powers, he said, and I quote, "Emergency powers cannot be circumscribed factually and made to conform to a preformed law." You can't have a law regulating an emergency and what is to be done. He said, and I quote, "These powers ought to exist without limitation, because it is impossible to foresee or define the extent and variety of national exigencies, or correspondent extent and variety of the means which may be necessary to satisfy them," which is again reflective of the thoughts of President that were just mentioned, which are also similar to the thoughts of Carl Schmitt on the point, who said, "Exception which is not codified in the existing legal order can at best be characterized as a case of extreme peril, a danger to the existence of the state." Of course, he then goes on to say, whomever gets to define that danger is the ultimate sovereign, a discussion with which we are not concerned with. Now, on the strength of ideas like these, it has been very regularly contended in the West that emergency powers are of the sort that are better not judicially reviewed at all. These are dirty areas, dark matters. Society has learned in thousands of years that it can only protect itself by force. And when it comes to use of force, there are things that courts better not be told. And then we go into areas of political science into which I don't want to go. But it is the Supreme Court of India, and in fact, the Bombay High Court, and during the colonial times, that are ringing endorsements of A, that judicial review of emergency powers is possible. B, there is a standard of review that can be used to review those powers. And C, this standard actually works. Now, at the end of the book, there is a long section that discusses post-Bombay jurisprudence, where it has been shown that Bombay resulted in use of emergency proclamations under 356 being cut in half, straight half. And then after Rameshwar Prasad's case, it went down even further. Now, how did the political system respond to this is not really a question that a lawyer is concerned with, but the fact of the matter remains that courts can review emergency powers. They can successfully review them. Indian Supreme Court's example. And here I think I'll agree with Justice Ramana. I think personally that Bombay is far more important, or at least equally, if not far more important, than Keshwaranda Bharti's case. Whereas Keshwaranda Bharti reined in any claim that could be made by the parliament that it is the ultimate sovereign, Bommai reins down that claim when it comes to the executive, the political sovereign, which is the office of the president, the office of the prime minister, and the cabinet responsible to the parliament. They are also not the supreme sovereign. The last thing I'd like to say, on which I'd like to end my remarks, Justice Ramana spoke about the wider context in which our constitution was drafted, which is very clearly reflected in the Constituent Assembly debates. And today, as it happens, is a very auspicious day. It is the 125th birth anniversary of Netaji Subhash Chandra Bose, who was active in the theater of war in the Second World War. Now, our constitution is drafted, emergency provisions very specifically are drafted in the shadow of the war that was just fought. The trials in Red Fort were going on. They had captured national imagination and so on and so forth. In this context, the Supreme Court of India knows, this is my analysis, and of course, I admit if there is any incorrect, anything incorrect about this analysis, but I think it's quite logical. The judgments of the Supreme Court of India very clearly show that the Supreme Court of India knows that when it comes to Article 352, there are limits that it can't cross. The concurring opinion of Justice Bhagwati in Minerva Mills case, and I'm quoting directly from the Supreme Court cases, this is 1980, Volume 3, Supreme Court Cases 625 at page 697, and I quote, and the quote is extremely important, Justice Bhagwati, rejecting the arguments made by Nani Palkhiwala that were designed to attack the validity of 352 proclamations, said, and I quote, there would be so many facts and circumstances and such diverse considerations to be taken into account by the executive government before it can be satisfied that there is no longer any grave emergency whereby the security of India is threatened by war or external aggression or internal disturbance. This is not a matter that is fit for judicial determination. You would see that the thoughts of Justice Bhagwati, before him Carl Schmitt, and that of Alexander Hamilton all point in the same direction. There are limits to which courts can go. Indian Supreme Court's jurisprudence, I think, is a shining endorsement of what can and what can't be done, and the courts constantly being aware. Remember, TADA, POTA, and later on UAPA, they have all been upheld. Now, in the academic commentary, they're all criticized, but the point is, when it comes to the security of the nation, even the Supreme Court of India knows that there are limits to judicial power and is usually contained in exercising them. I think all these important points are very well laid out in the book, and I think they raise many questions, which I think any good academic contribution should. And I do hope, and I hope Dr. Singhvi joins me in this, that future scholars take up these questions, attempt to answer them, and the onward march of scholarship should continue. With that, I thank all the Honorable Justices of Honorable Supreme Court of India, Dr. Singhvi, Dr. Raj Kumar, and all the listeners for their time today. I hope you find the book useful. Thank you so much.
Thank you very much, Kagesh. And we, of course, come to the last bit of today's program. I have great pleasure in welcoming Ms. Nupur Singh. But before I do that, I want to read one last endorsement by Professor Nathaniel Persley James McCarthy, Professor of Law from Stanford Law School, Stanford University, about the book. And he says, and I quote, Singhvi and Gautam provide an indispensable service with the publication of this book. The first of its kind, The Law of Emergency Powers, presents a foundational analysis of a critical topic for any country's legal system. However, the author's comparison of the British, Indian, and American common law system's approach to emergency powers is a triumph both in deep legal investigation of each country's particular approach, as well as broad description of important common challenges these regimes and many others face, unquote. Let me, first of all, thank Ms. Nupur Singh for championing the cause of this book, edited at Springer Nature, and handles acquisition and publication of Springer books from South Asia and Middle East region related to business management, law, and other disciplines. She has been associated with the publishing industry for more than 15 years, including a year's stint in Dublin, Ireland for international translations and publishing, a Dublin-based publishing enterprise involved in software and manual publication. She has worked with Indian publishing houses like Thomson Press and international publishers like John William Sons before joining the Springer. I'm particularly grateful to Nupur for her leadership, for her efficiency, for her promptness, and most importantly, for her appreciation for academic scholarship in this field and many other related fields. With that, I will invite Nupur to deliver a vote of thanks.
Thank you, Professor Raj Kumar, for that very, very warm note of appreciation. I'm like Kagesh, I don't know whether I deserve it, but I try to do my best to always live up to the great expectations that you pose before me. So a very good evening to the distinguished panelists and all those who have logged on to this online ceremony. It has been an absolute pleasure to be a part of this event. One of the positives of having to speak at the end of such an event is that all that needs to be said about the book's content has already been discussed by experts eminently more suitable than me. So I would instead like to take this opportunity to very, very quickly take you through the publishing journey of this volume. Which started in 2019. So my involvement started when Professor Raj Kumar first mentioned it in the second half of 2019, and it gave me the opportunity to be associated with another volume of great importance, in terms of topic as well as authorship with Jindal Global University. The contract was signed in October in 2019 itself, after a review process. And of course, the book received very rave reviews, very good reviews, no surprises there, of course. It was scheduled to be published early last year, in fact. And in fact, my last in-person meeting of 2020 was at Dr. Singhvi's house in March, just a few days before the national lockdown. And we got together to discuss the final corrections to the proofs. And at Springer, we pride ourselves on having one of the quickest publication turnarounds. But then even we could not anticipate a global pandemic's disruption to the schedule. But beating all odds, the book got published as part of Springer's International Law Books program late last year. And I'm really happy to inform everybody that it has already been downloaded by more than 150 researchers in less than 2 months that it has been made available through our portal. And I'm also happy to inform that a low-cost South Asian version is in talks, and I should be able to announce it soon. Again, it has been a huge, huge privilege being part of this work and of today's event, and I would like to thank everyone who contributed towards its success. Many thanks, of course, to the distinguished panelists, all judges of the Supreme Court of India, Honorable Mr. Justice Suryakant, Honorable Mr. Justice Sanjay Kishan Kaul, Honorable Dr. Justice D.Y. Chandrachud, and the chief guest, Honorable Mr. Justice N.V. Ramana. We are so very grateful to all of you for making time in your busy schedules, not only for the discussion today, but also to go through the volume and provide your very, very valuable insights related to it. I would like to thank the authors, of course, Dr. Abhishek Singhvi and Dr. Kagesh Gautam for coming up with such an amazing manuscript. And I would like to thank you for your patience during the publishing process. A special thanks to Professor Raj Kumar, Vice Chancellor of Jindal Global University, who has been the absolute dynamic driving force behind this book at all stages. And both the authors have already acknowledged it, and I would like to also add my special acknowledgement to it. It was an absolute pleasure to have worked on the book with this dynamic and very passionate team, and I look forward to more projects on such pertinent topics. And last but not the least, a big thank you to all the audience who have taken time out and not only joined but stayed till the very end, and on a Saturday evening, which is like really remarkable. And with this, I would like to pass the control back to the organizers to close the ceremony. Thank you all once again for giving me this.
Thank you very much, Nupur. And I want to first of all apologize to all our distinguished judges We have extended the program 37 minutes beyond our original schedule. We deeply appreciate your indulgence, your presence through the program. Thank you very much.